Thank you very much, and welcome to the Academy. Today, I want us to review the case, which is the public domain, and that is the case of Honorable John Waluke and two others, where the case that has led the MP to be taken to jail. And this review is based on a judgment that was already also in the public domain. So I just want to help us understand really what happened and what was the basis of this senior member of parliament or senior citizen of this country being taken to jail. And the judgment that I want to review was passed or read on 6th October 2022, that is this year. And it was based on an appeal, that these directors, John Waluke, Grace Wahungu, and the company that they own was charged in 2020. I mean, was sentenced in 2020 by a lower court, and then they went to High Court. And so the High Court also considered this issue and gave their judgment. And from the judgment, as we are going to see, the High Court agreed with the lower court and affirmed or confirmed those charges, as we are going to see. And so I want to give us a breakdown, a background of this case, and then I will be able to show you the sections of the case live on the screen, I mean, from the judgment, so that we may be able to learn together. So this case is an old one. It started in this manner. In the year 2004, there was a scarcity of maize in the country, necessitating the National Cereals and Produce Board to send out a tender for importation of a total of 180,000 metric tons of maize. Okay, and so that alone, I want us to understand that, yes, 180,000 metric tons of maize, and I'm going to help you understand that. Then the appellant, the one now that is appealing, that is the company that is owned by Waluke and Grace Wahungu, was among the 5 companies which were awarded the tenders and which entered into contracts with the National Cereals and Produce Board, and that specifically the contract between National Cereals and Produce Board and the third appellant here, that is the company that the 2 directors own, was for the supply of 40,000 metric tons of maize. Now, I want us to understand that. I want to just help us understand that. Now, 180,000 metric tons, if you convert that into kilograms, I want to assume 1 metric ton is equivalent to 1,000 kilograms. And so that would give you 180 million kilograms of maize. And if you convert them into 90 kg bags, that is 2 million bags of maize. Now, that is not so many. I mean, it is something we are familiar with, or somehow we have had, because recently in the country we were talking of, the government importing about 10 million bags of maize. I think it was much talked about at the beginning of this new administration. And so that time, probably because of the population in the country and probably agriculture was doing well, there was need to import, but import up to 2 million bags. So the cost per bag at that time, I would just give a rough figure of maybe 3,000 per bag. And 3,000 per bag, it means then the National Cereals and Produce Board required 6 billion Kenya shillings to be able to do that importation, and so that the country's scarcity would be sorted. And we have seen from that, that judgment, I mean, that is what the prosecution was presenting, that five companies were awarded the contract to supply. So if the 5 companies were awarded the tenders and they finally entered into contract, I'm emphasizing that because that would be the basis of some other, some other steps that they were taken, as we are going to see. And so they were awarded the tenders and they entered into contracts with National Cereals and Produce Board. And we have been told that specifically this company was given 40,000, a tender to supply 40,000 metric tons of maize. And so I was just trying to imagine, maybe if there were 5 companies, maybe company 1 was given 40,000 also, company 2, maybe 40,000, company 3, maybe 20,000, and then company 4, company 5. I mean, maybe the 4 companies were given 40,000 each, and 1 company was given 20,000. Just for purposes of agreement, I mean, of explanation, so that the 180,000 is covered. So the company in question was the 5th company, and it was awarded a tender to supply 40,000 metric tons. If we convert that into kilograms, that gives us about 40 million kilograms. If you divide it into bags, it gives you, into 90 kg bags, it gives you 444,444 bags. So it's about 450,000 bags. Now, at a average cost of 3,000,000, it therefore means that this company was to be paid about 1,333,333,333,333 shillings, roughly 3.3 billion. So 3.3 billion that they were supposed to be paid. So I want us just to have an idea of really what happened. So they have signed a contract. They are supposed to supply that, import and supply. And then what happened next? Now, they've been given a contract. They have awarded the tender, and they have entered into a contract with NCPB, and specifically the contract between this company, Mr. Waluke's company, and Honorable Waluke's company, and National Cereals and Produce Board have entered into a contract for supply of 40,000 metric tons, which we have seen is about 450,000 bags. Now, the contracts were predicated upon letters of credit being issued to the suppliers. Now, predicated means that they were tied to a condition that the contract would continue only after you are issued with a letter of credit being issued to the suppliers, but that only 4 of the companies were issued letters of credit because the funds ran out before the company in question, the third appellant, was issued with a letter of credit. So this is where this case revolves, that they were given the contract, they signed the contract, but now the letter of credit was not issued to them. And why? What is the letter of credit? Letter of credit is a guarantee that the entity that is procuring will pay upon delivery. And so what this company required, the company is called ERAD, supplies. I'll give you the full name. The company is called ERAD. So what ERAD required was that we have already been contracted. We have signed a contract. Now, for us to continue, give us the letter of credit so that we can use our money, but be sure that when we finally deliver, you will pay us. But now what they are saying, the NCPB was saying, the money ran out. They could not, it's like they didn't have the 6 billion at hand. So they could not give letters of credit to all the 5. So they gave to the first 4, which were able to be issued. Because you see, as you issue the letter of credit, it is the bank acknowledges that there's that money, and actually that money is committed and is set aside for that supply. And so there was no money. That is what they are saying. And so if there was no money, therefore, the third appellant was not, the contract for this ERAD was not honored, leading to a dispute between them, which was subsequently resolved through arbitration. And so this issue was taken to arbitration. And this is very common in contract law, where if there's any dispute, before you run to court, you can always go for arbitration. And actually arbitration, that committee doing arbitration has the same force. Their decision is as good as that which is done in court. And so they went for arbitration, and the person who represented ERAD in that arbitration proceedings was Honorable Grace Wahungu. And that is key, what I've just said, because it will help us understand something just in a short while. So she testified that the award was in favor of the company, and attempts to set it aside in court were futile. Now, what that means is that arbitration was successful in the sense that they won. So arbitration decided that they have to be paid. They have not supplied, but the basis is that they were given a contract, but now the company could not raise money. But for them, they are saying that they need to be paid because they have lost profit that they were anticipating. They also proved in court, I mean, in their doing arbitration, that they had purchased these bags of maize and were storing them somewhere in South Africa, awaiting for the letter of credit so that they could supply. So they were saying that they had been charged arbitration fee, storage fee. And so they were saying that they had gone at a loss. And so NCPB had to pay them. So you see, that is the basis of this case. And subsequently, the monies were paid because the accounts of National Bank, Kenya Commercial Bank, and Cooperative Bank of National Cereals and Produce Board were attached. And so they did not have any room. The accounts were attached in the sense that they could not do any other transaction, but they had to pay because there was an order given from the arbitration court. And National Cereals and Produce Board tried to make some appeals to the court to put aside this ruling of the arbitration court, but they were not able. So it's also important to understand that this company was owned by 3 people at this time. I mean, not at the time of arbitration, because the arbitration was being done in around 2009. But one of the directors at the inception of this contract was the late Jacob Juma. And then we have the Honorable Waluke and also the senior citizen, Grace Wahungu. And so what happened was that Jacob Juma had resigned as a director on 8th March 2006. And so by the time all these things were happening, he was not part of this. It was further the prosecution's case that the evidence relied on by the appellants in the arbitration proceedings That is the invoice that the Grace Wahungu produced, yeah, in trial court, purportedly issued by Chelsea Freight Limited, demanding for payment of $1,146,000 US in storage costs, was a forgery. So it was noted that during the arbitration proceedings, Grace Wahungu, and that was marked, it is clear that, I mean, it is proved that she was the one who represented the company, Erad Supplies and General Contractors Limited, during the arbitration proceedings. The invoice that she produced, claiming or indicating that they were being asked to pay for storage charges, that invoice that was said to be from Chelsea Freight Limited, a foreign company in South Africa, that was demanding US $1,146,000 in storage costs, was a forgery. So you see that position, that this was a forgery, and it was found out that the claimant was okay. That I'll say that it was represented by Wahungu, the second appellant, and that the said claim was that thereafter the Erad Supplies was awarded $3,106,000 US, and this was awarded by the arbitration court, and the basis was that they had lost $1,960,000 for loss of profit, and second limb was $1,146,000 as storage charges, and a cost of suit and interest at the rate of 12%. Now, this kind of money was so enormous, because if you do the calculation, and I have done the working somewhere, it comes to about 330 million shillings that they were claiming, or that they were awarded by the arbitration court. And then we find that one of the directors of the company that was in South Africa, that was said to have issued an invoice of $1.146 million for storage, came to testify, and he said that he was a member and a director of Chelsea Freight Limited, which was registered on the 25th of June 2002, and that the principal business of the said company was freight services. The company was based in Durban, South Africa, and he added that the other directors of the company were Alfred, and their names are there. He was the solely responsible for the company's accounts, and that neither the company nor its members or directors have had any dealings with the first, second, and third appellants, that is Honorable Waluke, Grace Wahungu, and the company itself, Erad Supplies, concerning storage of maize or any other business. He is saying that they have never dealt with these people, with the Honorable Waluke, and the other two, the director and the company. And so, according to him, that invoice, which was dated 22nd January 2005, of US $1,146,000, was not issued by Chelsea Freight Limited or any of its directors. That the invoice had numerous discrepancies as proof of the fact it was a false document, that did not originate from Chelsea Freight. And so this case is standing on this basis because they did not claim to have delivered the goods, but they alleged that they had stored them in South Africa and that they were being stored by Chelsea Freight Limited, and that this company had given them a demand invoice of $1,146,000. And it is on that basis that they were awarded the huge sums of money that they were awarded, because they were said to have lost profit because they were holding the maize, and they had also had to pay the storage charges and the interest. And so Chelsea Freight had neither been involved in maize shipping or storage in South Africa or any other country, nor had it conducted any business with the appellants, and further that the invoice was a computer printout and did not bear the signature of any of the directors or the company stamp. The witness vehemently disputed that the invoice was issued by Chelsea Freight. So you find that was a big allegation. And you find it's also testified that on 19th March 2013, Kenya shillings 297,386,505 was transferred via RTGS to the bank account of Soita and Saende Advocates. That the money was afterwards disbursed as follows. And now that money was payments now started. The amount I've told is about 330 million that they were being paid. And now, why are they being paid is for storage charges, which have now been said to be fake, and for loss of profit, which is fake because they didn't purchase anything, and then the interest for the period that they had waited. Now, I want to underscore here that had this thing been, the invoice been correct, that they were claiming the storage charges, rightly, if there was no fake or forgery claims, then it was still in order because that clause on arbitration is a valid provision in the contract. But because it is being said to be fake or a forgery, that is why it is very difficult for Honorable Waluke to escape this. And so we have seen now on that 19th March, you see after back and forth of this issue, the NCPB also trying not to pay this money and trying to take the issue of arbitration, the report of arbitration to court and challenging it in court. Finally, they were caught. They were cornered and asked to pay. And so we find that they have paid now 297,386,505 transferred by RTGS to Soita and Saende Advocates. There is a breakdown of how that money was paid out. You can read it for yourself. And then the investigating officer, the name is there, in the case testified that he sought mutual legal assistance from the Republic of South Africa to verify the particulars of Chelsea Freight and his involvement in the supply of maize to the third appellant, that is to Erad Supplies, that he recorded statements from 2 out of the 3 directors of the company who denied having ever dealt with the third appellant. So I want to just to, have that background and understand that this case stands on the strength that the invoice that was produced was fake and it was disowned by the alleged directors of Chelsea Freights in South Africa, and the investigators or the prosecutors, prosecution side did their very best to do investigation, follow up to South Africa, and confirm that whether there was such a company and whether it did any storage for errant supplies. And probably arbitration didn't do much because they should have also done a bit of due diligence. But I also would excuse them because at the point of arbitration, this case is still a civil case. And so the level of the kind of evidence that they are requiring is not so much of a detailed investigation. And probably that's why this case was able to reach this far. But from what the directors are saying is that even at the face of it, the invoice was a printout. And so probably those things would have been picked out. But anyhow, here we are. The case now mutated from an ordinary civil case to a criminal case. And that is why you are seeing the kind of charges and the kind of sentence that Honorable Waluke has befallen Honorable Waluke and Honorable Grace Wahungu. So I want to stop there, but I think that gives you a better background. Probably I'll do a second video to show you the defense, how they defended. I think Honorable Waluke may still have some leeway, especially that he is saying that he did not represent attend the arbitration. He did not engage with any, did not produce the invoice. He is trying to say that, and probably trying to leave this issue on the hands of Grace Wahungu. I don't know how it will go, but that is the background of this case. And so thank you very much. I want to hope that you learned something. And I want to ask that you subscribe to our channel so that every time we do a video, you are able to get a notification and learn something. This channel is for education. I mean, we only pick topics that are of interest to people and we dissect them so that people may learn something. So thank you very much and welcome again. Please subscribe.